Welcome to the top 10 things not to do with intellectual property. I am your moderator and host, Jerome Fogel, co-founder of Fogel and Potamianos. I have here with me my co-founder, Constantine Potamianos, and we have a very special guest, Robert Kramer, who is our senior intellectual property attorney extraordinaire. And he is going to cover a fantastic presentation, which I've seen for those of you that are around the country watching. Before that, I do want to make a couple of introductions. Let me introduce myself. I'll let Constantine do that, and we'll get into the presentation. So again, my name is Jerome Fogel. I'm a corporate and M&A attorney with Fogel and Potamianos, and we work with a lot of small and lower middle market companies, and really excited to be here today. And Constantine, I'll let you introduce yourself.
Sure. As Jerome mentioned, he is my co-founder in this firm and an awesome person to work with. My background is primarily out of the corporate and securities world, where I spent over 20 years practicing out of New York. And now I head up our Austin office, Austin, Texas. Because of the work that I've done over the years, I've come to realize and appreciate the value of intellectual property as a corporate asset, as a growth strategy, as a means of protecting your proprietary rights. And therefore, I think this seminar is critical to anyone in the business world. And I think Robert is the premier presenter to lay this out for us.
And to piggyback off what you just said, Constantine, so Robert has spent 2 decades as an attorney procuring and managing IP portfolios. He's worked with inventors, physicians, startups, large institutions, and corporations. He's been on billion-dollar, litigation matters. He's prior to this been an engineer in aerospace. So he really, from the ground up, looks to build IP assets, and he's also got an eye to make sure that no litigator can try and tear down your IP. So with that, I want to give it to Robert Kramer. Rob, thanks so much for being with us, and I'll let you have the run of the show.
Thank you, Jerome, and thanks, Constantine. That was very kind of you. You did a great job in explaining my background. Just to give a little bit more on that. Number one, I love what I do. I love working with entrepreneurs and startups and companies that really are making a difference in the market and in our lives. And so this is incredibly rewarding to me. So I hope I've structured this to really provide some value to someone who may not be too familiar with intellectual property. And even if you are, I think there's going to be some things in here, some insight that I will be honest, a 5 or 10-year younger version of myself, I may not have had some of this insight. So really, with that said, I'll go ahead and jump into the presentation. I'm going to share my screen here. I think Jerome mentioned we will be having a quick Q&A session, so I'll table that till the end. And so hopefully it'll be explanatory, but I'd be happy to answer questions at the end of the presentation.
And if those of you that are watching, if you have a question that pops up and you're burning to get out, go ahead and put it in the chat, and we'll just put it in the queue for you. And then once the presentation is done, we'll make room for that. So just keep that in mind. I'll keep a running tab of the questions as they come. Go ahead, Rob.
All right, thank you, Jerome. So I'm hoping that you're seeing our introductory page here, top 10 things. So this is mistakes that can be made either from the client itself, could be the attorneys working on the matter, inside counsel or not. But these mistakes are generally some things I've seen in my experience that are across the board. from the most sophisticated to the least sophisticated, user. So looking at our first slide, I think, again, now stepping back a little bit, these are not in any particular order as far as what is the worst mistake, but I want to start with this. And I think one big mistake that particularly practitioners can make is really failing to look at the big picture of intellectual property. I've put the 4 primary components here that I think apply to intellectual property law, and I want to kind of go over a little bit of each of them, what they are, how they distinguish themselves, and where overlap can occur, because this is where I think mistakes can be made in practice. When you look at intellectual property itself from a practitioner standpoint, from a lawyer standpoint, there tends to be a path to focus your practice on one of these areas of law, and there's good reason for that, because they're highly complicated, and even within patent law, for example, you'll find that there will be practitioners that only practice on the prosecution, the transactional work of getting a patent, and then there will be people who only litigate. And even then, among the guys and women who just try to get you a patent, there's disciplines within that. For example, you can have people who concentrate on electrical engineering, chemical engineering, biopharma, medical devices. And even within that, you can get so the tendency here is to become very almost pigeonholed or focused on your craft. And trademark attorneys, who tend to be really good lawyers, generally get in that realm of work a lot of times because they don't have that technical background that a patent attorney will have. And so in a lot of instances, there will not be that congruency that sometimes is necessary to really look at all of these areas of law and the particular client's business. So briefly, when you look at patents, patents cover inventions. This is the most finite term of all of the areas of law here. Patents are generally 20 years, granted for 20 years beyond the filing of the application. And then at that point, the patent becomes the public domain. Trademarks, on the other hand, can exist in perpetuity, as long as you keep selling that product or service. You will and maintain your trademark. You can keep it as long as you're as I said, doing that business. Trademarks, unlike patents, they cover the source of your product or service, and so you have to have a sales in commerce to be able to get a trademark. That's one requirement of it. Copyrights cover expression, and that expression can be artistic. It can be also expression in writing. It can be a list. It can be artwork. Anything that is expression, and it only covers copying of that expression. So if you were to look at a list or a particular piece of art and you did your own version of it, then copyright law will likely not protect that use. Finally, with trade secrets are exactly that. They're secrets. There's something that a company can keep internally, protect others from getting to any knowledge of that, and use that in a way. A common trade secret that we all know is the formula for Coca-Cola. It's been around forever. It will live also in perpetuity as long as Coca-Cola maintains the processes they use to maintain that secret. And so there are advantages to each and every one of these. Patents can have a very broad scope and protect, you know, your intellectual property in a way that trade secrets, copyrights, or trademarks can't. You know, so looking at some of these examples here, now we get into the areas where there may be, you know, common aspects of a technology or an aspect of a business that could apply to both, you know, or all of these four areas. For example, you know, software formulas, processes, business, manufacturer processes. These can be trade secrets. They can be patents. They can also be copyrighted. Software is often copyrighted. So it's a good idea to look at what is the best way to cover something. You know, for example, code. Because copyright only covers copying, if someone gets your code, they can re-engineer it in a different way and still use that to their advantage. That's why a patent can be very, very valuable, because we're covering the functionality, the utility of that software. Trademarks, one thing that a lot of people don't, you know, see or put a lot of attention to is trade dress, how something looks and how that look of that product or service identifies the source. That look of that product could have a functional value as well and relate to a patent. It can be a design that can fall under a design patent, a utility patent, or trade dress. You know, recipes or lists, these could be copyrighted. However, if someone were to change small variation of that list or recipe, then their ability to use that is not going to be protected under copyright law. You can also try to keep it as a trade secret, and that way, you know, if no one knows what your list is, then it's secure. One area of law here, if you do notice, I have this little purple spot here. Yes, you're saying that, Rob, unicorns don't exist, and that is precisely why I put that there. It's because trademarks and trade secrets have, their purpose is so opposite from one another that there is nothing that I could think of that falls under a trademark that you could also follow under put under a trade secret. It's because trademarks, you have to show use, you have to identify that property with the source of the product. In trade secret, you're actually trying to hide that secret property, that value, from the public. So if you do come up with something, let me know. I'm just going to keep that an area where there is just simply no crossover. Okay, so here's some examples, some real world examples of how these things interrelate. For example, looking at the gun. I'm not trying to be shocking here, but you know, if I were to open up to a question, does anyone recognize what model of gun this is? Take a guess.
Constantine, you probably know. Constantine, you probably know.
Yeah, I'm going to say it's not a, doesn't look like a Glock to me.
Well, it actually, you're right. It is a Glock. And there's something that there's a reason why there's features of this gun that are Glock like, and that's one, the trigger, because it's a silhouette. You may not have noticed it in detail, but this slide, a bulky slide with a couple of rivets. So this gun is what this silhouette is what you would call trade dress. Glock is actually very infamous for being litigious. In fact, I think my cell phone's ringing right now. They know I'm using this slide, and they're giving me a buzz. But no, seriously, Glock has done a lot of effort in protecting the look of their gun. They will go after anyone who makes even a airsoft gun that looks like a Glock gun. And in fact, there was a multi-million-dollar lawsuit in their favor against a manufacturer of an airsoft gun that had these features. And the thing about trade dress is it's not supposed to apply to a functional aspect of a device. That's what patents are for. However, they have gained this ability to keep others from using these features, even though they may be functional. And that, as I explained before, is of incredible value beyond possibly even a patent. If they were to try to patent that slide or that trigger shape, that patent would have long expired by now. But now they have this almost infinite ability to go after anybody and everybody. You may be able to tell them, hey, you're not allowed to do this because those are functional features. And coming from someone who's tried that, Glock will still come after you. And they've made this a very valuable asset to their portfolio. Similarly, Pez, the Pez dispenser, their original patents on the Pez dispenser issued in 1949, 70 years ago. Their patents have long expired on the original patents. However, they are still able to make competitors comply with not copying the shape of their product. Another area that I think practitioners can sometimes overlook is the design patent. It can be incredibly valuable. They're somewhat much more simple to get. Their scope isn't as broad as a utility patent because it covers the ornamental feature. Of course, everyone probably can recognize this right here. It's an iPhone. And iPhone patented this design and was very successful in keeping most competitors from even using this square rectangular form with a slightly rounded edges. Now, Samsung did go that route, and there was an incredible amount of litigation involved there. But a lot of the success of the iPhone, I think, it comes from the form factor, the way this device looks, and it has been an incredibly powerful tool for Apple. Okay, so that's just kind of an overview of the four areas of law. We'll go into what I think is possibly now what the biggest mistake we will see, and that is not filing for protection and or filing too late. And this sure does sound self-serving to a IP attorney. Say, yes, my job is very important, you really need to do this. But I'm really coming from this from an experience standpoint, and why I think this is possibly, if there's one thing in that I would hope that I can imprint of anybody looking at this presentation, and it's the first bullet here. And it has to do with patents. If you publish, sell, or publicly use your invention prior to filing an application, you will completely lose any right. You will be barred from filing a patent in almost any foreign jurisdiction that matters. In the US, you get a little bit more leeway. You get a 1-year grace period. And that, as of 2013, with legislation patent legislation that occurred in 2013, publication of your patent may not even be that clear. So for a patent, it is, I think when you look at most consumers, I think that people think of protecting their idea more so from a standpoint of, yeah, I don't want someone to steal this idea. But really, it's surprising how few people in the industry, whether it be you know, executives or startups, don't have a full grasp of this concept right here. And so, you know, it can be incredibly disastrous if you start publicly using your invention, publishing it. Universities are famous for that, because their physicians and their professors love to write papers, and you know, these can be catastrophic. So again, you know, before you do anything with your patent, it really is important to make sure you've secured rights. Otherwise, you have basically given it to the public domain. Trademarks, it is also can be incredibly important, although maybe not as catastrophic as patent law. In trademarks, you have the ability to file or rely on common law, meaning the moment you start selling your product, you do have trademark rights. They're state rights or local rights, and you have some protection there. However, those rights are only geographically specific. So for example, if you start a painting company and you're only operating in Northern California, your rights are going to be to protect against anyone else for that use of that trademark are only going to be in Northern California. So by filing for a trademark, you gain national rights immediately upon using anywhere. And that is, it can be very valuable to someone who's building a practice or building a business and maybe starting off locally. Now, also with trademark filings, trademarks are granted to the first filer. So you want to file early, even if you're not using it yet, because that registration date can be an advantage for you. So a company who is just starting up, hasn't generated sales yet, maybe they're still have to get some sort of government clearance, they can apply for a trademark and keep it in a state of extension for up to 3 years before filing, and in a sense place their stake in the ground for that trademark. Now, as far as all these whether it's patents, trademarks, and copyrights, this last bullet is also incredibly important these days, in that if you are an online reseller, if you sell products or services online, and especially in the advent of the last few years, it is incredibly to your advantage to have a registration for one or more of a trademark, patent, or copyright. And the reason being is that all these entities such as Amazon, eBay, you name it, will have these portals that allow the seller to simply identify somebody else's use. Say they're copying your mark in some way, or they're using a product that is covered by one of your patents. You can simply just file a complaint with that entity, and they will, almost no questions asked, pull the infringing listing from use. And they act as the judge and the jury, and there's nothing the other person, very little they can do about it unless they can present a case against it. So in a sense, you know, you have a competitive advantages online that was never seen before prior to the advent of these online resellers. And so I will say unequivocally, I have a number of clients who use this to their advantage, and it's a little bit unfair to some of the people who because there is no judge there. It's just simply they're cut off. And so I can't say enough that in the up and coming marketplace, the evolution of online selling, that these things are becoming more and more present.
Rob, can I ask you something?
Yes, absolutely.
I was thinking about it in looking at this title and thinking about not filing for protection or filing too late. And you may talk about this later, or you may bring it up, but I was thinking from my experience, you know, in your IP strategy, you're trying to build a wall around your intellectual property, your competitive advantage as a business, as an inventor, or whatever the case may be. And I tend to think of a patent as one brick. It's a component to the wall, but not necessarily sufficient. And I think sometimes business users think, okay, well, if I just get my one patent for this particular technology or application or whatever, I'm good. And I think they forget sometimes that there needs to be an ongoing strategy about how do I continue to build this wall? How do I do additional patents? How do I start to build a patent family, for example, around my technology? How important is that? And how often do you see that not being considered by clients?
Yeah, you know what, Constantine, that's a great question. And it actually brings up a bullet point that I considered it didn't make the cut here today. But you know, and that is particularly with patents. One patent is great and can be incredibly powerful. But when somebody comes along, you know, it's very hard to see in the future. You could try to do everything you can to be as broad with your protection on a patent. But if someone were able to get around your claim, you know, the bounds of your property, then now, if that's all you have is that one patent, you're going to be handcuffed by the scope of that protection.
Let me put it in a different way as I think about it, right? From a military perspective, it's really hard when you're taking fire to huddle behind one brick. You want as many bricks around you as
That's really
possible.
good.
And when you build that IP strategy, you know, you're either at some point you're building it because you expect you're going to be taking fire. Either somebody's going to try to attack you directly, or somebody's going to try to do what you're doing, and you're going to have to defend and be able to take their return fire. And I think that's kind of the concept that sometimes companies don't understand.
Yeah, absolutely. And that's why you will see companies with portfolios of patents to even cover one product, because you know, you may get a scope in one section, but then to really try to, you know, it may not be the grand scope of really what you want. So you got to pick at it, and like that Venn diagram, try to piece together the larger area of protection. And also with respect to patents, you always, even though you have a patent granted, you always want to keep one in waiting, meaning file a continuation, because what that allows you to do is then morph your claims in a way that may cover someone that in a way that you never thought coming. And so if you don't have that continuation, if you let that patent, in a sense, that lineage die, you don't have the ability now to go back and claim priority. Once the patent issues and you don't have a continuation, that's it, it's done. So that's a great point. And again, I think that's also a mistake, is allowing one patent to be a one and done. You should always have one patent continue to go if you are continuing to evolve or you're in a marketplace that is evolving. All right. So let's move. We're on 2 of 10, so I want to make sure I get to this.
Again, sorry.
Yeah. Okay. So Another mistake that I tend to see more than I would expect is, use of these symbols. Again, not only, do I see use of symbols, for example, the circle R trademark where a copyright should be used and vice versa, but also people tend to use these when they shouldn't or can't. So to back up on trademarks, you'll see the uppercase TM, and what that means is that you've started selling your product and you have common law rights. You haven't gained a registration, but you do have some rights, and at that point you can and should use the TM symbol. That's an indicator to people that, hey, I'm protecting this mark. It's important to me, and stand back. Now with the circle R, now what you're saying is not only do I have common law rights, but I have filed a registration and I've gained a USPTO registration for this trademark product or service. Now this also sends a message that, okay, I have nationwide protection with respect to this mark, and I have the benefits of that protection. One thing to note here is that I have seen businesses use this when they don't have a registration. And this can be incredibly problematic for them, because there can be penalties for use of that, and the patent office does not take it kindly. I have in my practice come across somebody who didn't like the use of one of my clients' marks, and had noticed that they were using this symbol and they had not gained a registration. And I will tell you that basically it puts their counsel, the opposing counsel, dead in their tracks. There was nothing they can do, because at this point, the patent office was never going to grant them their use of the mark because of them using this in a potentially fraudulent manner. With respect to patents, once you file a patent, and it could be a provisional or non-provisional, and we'll get to that later, you can put patent pending, and should put patent pending, on your product or website, however you want to identify what you're selling. After you have gained a patent and a patent is issued, then you would use the US patent number and the actual number to identify, mark your product with this. The benefits of doing that is that this puts a potential infringer on notice. And even under a patent pending status, damages can accrue for someone using your technology even before you have the right to protect against it. Copyrights. This one kind of throws a wrench in the above, because copyrights, you can use that circle C the moment you publish your work, whether you got it registered or not. So it's a little bit opposite of trademarks. If you have an image, a photograph that you've taken, or artwork, you don't have to file for a copyright. There are definitely benefits to do so, but you can file that or place that C on there whether or not you've registered.
And when we say publish, we don't mean publish in the traditional literary sense. We mean just put it out there in the public domain.
Absolutely. Thank you for that clarification. Yes, exactly. Publishing can mean, if I were to even just simply have a website that shows my image, that is publication. Okay, number 4. So we'll go to a few with patents, a couple of trademarks. This one's patent specific. One big mistake I see inventors, companies try to make is they want to keep the good stuff out. It's like, hey, we don't we don't really want to disclose this because I don't want someone the ability to copy it. But the problem is that's the trade you got to make with the patent office. That's why patents exist. The patent grants you this right to exclude others from making, using, and selling your invention as a trade for you, enabling, showing someone how to make and use your invention. And that eventually, after your term, their 20-year term expires, that is now granted to the public to use as theirs. And so if you don't enable your patent, it can be invalidated. I see this a lot with people with software type patents, methods. They don't want to throw the source code in, and unfortunately, sometimes without it, you're not enabling someone as to where it is your invention lies. Formulas can be part of this process, but again, a lot of inventors, they simply just I want to keep the secret sauce, to myself, and unfortunately, that can lead to a lot of problems. So not only with enforceability, but also with patentability. And in this next slide button here, in many cases, the broader claims are not what you get. You get the stuff that really lies within the details in your technology. So in all senses, unless you find something that you can hold as a trade secret that can't be reverse engineered, the best practice is to include anything and everything. And that includes all alternative configurations that you can think of, because that can really help with the scope and enforceability of your claims. Okay, number 5. This one's a unique one, and I think it's I think that most practitioners don't even put a lot of credence to this, and this is a benefit that I think, well, number one, it only applies if you're filing a U.S. patent. It's not applied to foreign or PCT patents, but this is it has a couple of benefits. Number one, if you just simply file for a patent at 18 months, it will publish. And to some that may not be a big deal at all. However, there are a lot of instances when you file in a patent, and then a couple years down the line, you have an improvement, and now you want to file on that improvement. And if it's new matter, you can't throw it into the first application, or you could in a CIP, but that publication can still be used as a public disclosure. I remember the 1-year rule in the US. So if you don't publish, in a sense, it's hidden, and this issue goes away because no one will see the patent. It can't be prior art against you until the actual issuance date of your patent, which could be 2 or 3 years later, much longer than the period for publication. Also, under the AIAA, the new laws, third parties can submit their own submissions to try to tank your patent. And once you're published, they're on record of this. They can sniff out this and start to file all sorts of documents that can be incredibly difficult to overcome and expensive for attorneys to now have to protect against. And in a sense, instead of one examiner, it's like having any number of examiners of people who don't want you to get that patent. So, I think this is something that can be very valuable for some companies that don't want to file foreign, because you can't file a PCT that doesn't have a publication at 18 months. That's just part of the rule. So, but if you're only filing in the US, this can be a valuable tool, and I think it's overlooked. Okay, also with patents, people rely a lot on a provisional application. Now, just to get some background here, provisional application is somewhat of a temporary application for those not familiar with it. It's never examined. It doesn't give you rights. Not a lot of requirements, and so it ends up being a low-cost way to get patent pending. It can be very valuable. It allows you up to a year before you have to actually file the application that will get examined, the non-provisional application. However, a lot of people use this as just, they'll just throw something out there. It could even be a disclosure on a napkin. And the problem is that if it's not enabled, it won't provide you priority that you're looking for, because you have to enable someone how to make and use your invention. So provisional applications get overused in ways in that they act as placeholders, but if they're not adequately described, you can run into a lot of problems. So this is another area we tend to see a lot. Unfortunately, sometimes you just have to do the work. All right, moving on to some trademark, common trademark mistakes. One mistake you see a lot is that people will file for a mark without really searching as to whether somebody else is using this. And you know, there are services that provide a search. They can be very extensive and expensive. So that's one of the reasons why people just, you know, I just want to file for the mark. But one thing I tend to do for all of our clients is I will do at least a preliminary search. I'm gonna, you know, number one, we look at the USPTO database, and we do an internet search, and there's a reason for this, because a common law mark can still cause you a lot of problems. So it isn't registered, it won't show up in the USPTO database, but there are marks out there that someone didn't apply for, but may have some geographical scope that, if they're in Georgia, well, now you can't sell in Georgia because you have a mark that is similar to theirs, and they've been using it before you applied or used your mark. In that same sense, just looking at the, you know, doing a search on your term can be problematic. You need to look for sound-alike marks. For example, there's litigation, you know, that found that the use of the term exceed, because it sounds like exceed, was confusingly similar. So if you only put this term in your search, exceed won't pop up. So you have to be somewhat creative with your search. And you know, this is another example. You know, you have to use sometimes numerals now. A lot of people use 8 instead of you know, ATE, and so there's a lot of those instances that that are overlooked when you don't do a proper search, when you don't search your mark. Number of headaches can happen down the line with gaining allowability, and with enforceability, and with somebody else coming and saying, hey, we've got senior rights to you, even though you may have had a registration that we don't even have. Okay, this is another huge thing I see with a lot of clients, is that companies love to describe their product or service in their trademark. It's just a natural tendency to do so. You know, the problem is that the patent office that doesn't want to grant you rights, and the courts in common law, to something that describes a product, because it's not fair. I mean, you should be able to say that you're selling beer. So if someone, you know, markets their product as cold beer, well, you know, that's overreach. And so patent trademarks, patent office, they don't allow like this overreach. So it can really be difficult to gain allowance. If the patent office allows it, they will make you do something called put it on the supplemental register. And then you have to wait a period for 5 years, and then maybe you might be able to get that mark at that point and show some sort of secondary meaning with your descriptive mark. But even if it gets allowed, it's going to be weak. So, what we like to see as trademark attorneys are one of these three things, or combination of these three things. Fanciful marks, like Adidas, one example. Arbitrary marks, Apple. Apple, what does that have to do with computers? It's arbitrary, but it's a very strong mark. Or suggestive marks, Coppertone, North Face. These are much easier to acquire, and they're way stronger. However, the tendency of businesses to follow this rule never seems to go away. We battle this constantly. We do. Oh, we're getting close here. This is a quick one here. Not filing for incontestability. We see this a lot. If you have a trademark at 5 years, you have to file a renewal. It just basically says you're still using the mark. You make a declaration and you pay $125 per class. Well, along with that, you can also file something called a Section 15 declaration. It can be in the same document, and you pay another $200 and you get something called incontestable status, or immunity from legal challenge. There's nothing that I could imagine that is cheaper than $200 for getting something with that status. For whatever reason, we don't see a lot of businesses doing this, and I think that's a mistake. And then finally, get one trade secret slide on here, because you know what? Hey, trade secrets don't get a lot of love. So trade secrets, what makes a trade secret? Okay, Coca-Cola has their formula here. How do they get to maintain keeping their formula and keeping others from using it? So a trade secret is information that has economic value because it is secret, and that you use reasonable effort to keep secret. So those are the requirements to make something trade secret. How do you do that? You do what I call you create an evidence trail of your efforts to keep something secret. So number one, you create a company policy and procedures with respect to trade secret proprietary information that you're keeping secret. You restrict access to those people in your company on a need-to-know basis. If you are going to disclose to a third party, you have to have an NDA, non-disclosure agreement, and keep the stuff in a safe. You got a formula, keep it in a safe, and you show that. So that's it. That's I think I ran a little bit over, so I'm going to stop sharing here and open up to questions.
Fantastic, Robert. I actually got a couple. First off, the images were stunning. The presentation was phenomenal.
Thank you.
I mean, I really enjoyed it. I think our audience enjoyed it. We already have a couple questions. So these are more topical questions. So one question is, Robert, if you could address film content, intellectual property in the film business. And the second question relates to medical devices. Can you address intellectual property in the context of medical devices? So two subject questions, one about films and one about medical devices.
Yeah, so film, now what you're talking about is an expression, right? Film is not going to fall under, trademark could loosely apply if you have a name of something and you want to establish a brand with that name. For example, Star Wars, and you're selling Star Wars products. So, but now just the actual film itself, the content of the film, now that involves copyright. So if someone wanted to remake Star Wars using the storyline, they're free to do it. But you can't simply just redistribute or copy any version of the actual film. Otherwise, you're in violation of the copyright. I don't know if there was a more specific question with that, but that is how a film would be protected in general.
And I guess
Why don't you go to medical device, and I'll ask and see if there's more, if that was a significant sufficient answer. Let's go to medical device, and then Constantine gets something to say.
No. I was going to talk about the film subject for a little bit because it's not an area that I'm particularly familiar with. But I assume it's not only the film, but if you've created characters within the film, they can be copyrighted and not necessarily used in other creative works by somebody else. But also, I guess the question also arises in the context of using, trademark usage for products that end up being shown in your film, deliberately or accidentally. I guess there's a whole host of intellectual property issues that arise within the specific film industry, depending on, which perspective you're looking at.
Well, yeah, for sure. So when you look at, for example, some of the Marvel films, right, and you have Spider-Man, and Spider-Man has that costume, and someone were to create another character with that, there absolutely could be some violation of rights there, because you've now if they call him Arachnid Man or something, and then change the outfit,
battles between DC and Marvel about their characters.
But yeah, use of Hulk, the Green Man. There's some good questions there. Anyone looking green and big, are you now violating Hulk's copyrights? That could now start being a stretch. Who knows?
Looks like
here's a question, Rob.
Yeah.
Here's the question. So if a studio owns the rights to a book and they've never published it, and the rights have been sitting for 30 plus years, a long time, and if an independent studio produces that content and distributes it without obtaining the rights, would that be a problem?
Well, that's a very specific scenario there. So, okay, so you haven't published, so you have rights to a book, but your rights are what? They're contractual, right, with the author. Nobody else knows them. Your rights lie between you and that author. There isn't any copyright now because you haven't published. Copyrights, like trademark, require an extra step beyond just the generation of the content. So like trademarks, where you have to actually sell your source, in copyright, you actually have to publish in some way or not. So you've been sitting on this. Now somebody else comes in and they somehow steal the story, right? It looks like, and then generate a film. I think is that.
Yeah,
basically
another producer who doesn't have the rights to the book basically produces the film based on the book, but never got the rights from the author. Would that be a problem?
Well,
or the studio?
Again, this that's a very specific legal question. My impression, and it might take a little, there might be some research involved in there, but my impression is that copyright hasn't attached because there is not a publication yet. So there is no right to go after the person who now stole that content. That comes someone in the you need to keep that stuff secret if you're not going to publish it. Now the thing is, now can they say they're the original author, because copyright protects the author? So that would be difficult for them to say, now you can't publish your book, because they may not have the ability to try to say they have any rights to that work, because they are not the author of that work. So very unique problem. And it would take a little bit of investigation, but those are my initial thoughts on that.
Great. And then one last question on a few minutes we have left. And by the way, those of you who are here, we're going to give out contact info if you want to contact, Rob and reach out. He's here to talk with you. Question is, what's the content of IP in the context of medical device space? How is it unique in that space when you're doing IP?
Well, medical devices are somewhat unique, and then there's some special rules that apply because they are medical devices. Number one, medical methods are generally not enforceable against physicians. And that is more of there's a special statute that specifies that, because we don't want physicians from being able to practice life-saving and or life-changing measures. So a method has different distinction for patents in medical devices. Now, the problem is that you don't want to shy it away from still using a method in medical device, because it can be incredibly powerful still, and I'll get to that, and also it can be the only way you gain a patent. For example, a catheter, there's a bazillion of them, but sometimes the way you use that catheter or the way it's inserted, and maybe some very subtle changes to it allow it to be to provide a novel procedure. You can get a method in the US. The US will allow you to gain a method claim, but now the question is it enforceable? Well, it is under contributory infringement, meaning if someone is making a device that's specifically implemented to use that method and they're advertising it for that method, you can still find them for infringement. It's not a direct infringement, but it's called a contributory infringement. So method claims, what I do is I structure them to have some structural elements in there, because I want to tie it to a particular device that someone will have to use. And it allows me to still kind of subvert that statute that says, okay, you can't prohibit physicians from practicing imaging. So that's one thing that medical devices are unique in the patent space, that I think a medical device patent practitioner really needs to be privy to.
Fantastic. So if those of you that are watching, we are going to give out Rob's info, and you'll have an opportunity to follow up with them, whether it's on film or medical devices or what have you. I think this has been truly enlightening, Rob. I've learned stuff I didn't even know before. Really a fantastic presentation. Thank you all so much for joining, taking time on your Friday. We wish you all a great Thanksgiving next week. Happy and safe Thanksgiving. Constantine, any final words?
No, you beat me to the punch. I was going to wish everybody a wonderful Thanksgiving, but you got there before I did. So thank you.
Okay. Well, thank you, Constantine. Thank you so much, everyone, for joining. And look out next year. We're going to have a upcoming panel on predictions for 2021. This will be after the election, not the election predictions, but business predictions for 2021. Look out for that invite forthcoming. Thank you all so much again for joining us for the top 10 things not to do with intellectual property.
And
have a great day.
Have a safe and healthy rest of your year. Thank you, everyone.
Thanks, everyone.
Thank you.